Hi there. This is Danny Hammond in Kansas City. I'm with the Foreclosure Solutions Group. It is June 25th, Thursday, and we're about to come up with a schedule for the real estate classes. And I'm getting a lot of questions about where the classes come from. What is it you're going to try to teach? Why aren't you helping people anymore? I'd like to answer some of those now and kind of bring it up. But actually, we're experiencing right now, we're seeing on TV almost every night for the last 3 weeks, something that we were familiar with, if you're old enough, to go back to the 70s and the Watts riots in Los Angeles and the 60s, and it was all about civil rights. And so what I'm talking about now is if you run into a situation where you're being deprived of your civil rights, and there's one person in your way, and he has absolute power, and he will not follow the rules of Article 3 of the Constitution, which is the judicial article. There were only 7 articles in the Constitution originally, and it's number 3. And there were things that they were afraid of, the framers. For one thing, they just fought an 11-year war, a lot of people don't know that, from 1776 to 87, against a tyrant, a dictator, an absolute monarch, a deity, in King George. And they fought him in a war that no one thought could be won, and they fought much longer than you'd ever believe, and people believed strongly enough in their right. Basically, it was a right to representation. They were being taxed, give us the money you owe us because we're protecting you, without any representation in England. They weren't part of Parliament, they weren't part of anything. And so the real issue was taxing without representation. And so they built into the Constitution the separation of powers. And the courts, they knew if they separate them and if they gave these judges, and remember there was only one court, it was called the court, not the Supreme Court. All courts are descended from the Supreme Court, and they exist only at the pleasure of the Supreme Court, which all you people that are in state court, and you've got your judges saying, well, our state law is, it doesn't matter. For one thing, there is no state law that contradicts federal law, and there is no federal law that contradicts the Supreme Court's definition of the Constitution. The Constitution is very broad, and they meant for it to be. They knew times would change, things would change, things would be invented. These are guys that never rode in a car, they never flew in an airplane, never saw a real highway, and yet what they wrote was variable enough to allow for changes and stiff enough to make the changes hard. So what I'm saying is that each of you that have been in state court and federal court, or state court, federal court, or federal court, appeals court, and the judge in each of those simply did not pay attention, did not read what you wrote, I'm going to tell you what the problem is. But you know what? The remedy is in danger. The remedy is the Constitution. The remedy is that if a judge does not look at what was written by the foreclosing party, and I'm talking now just about us, the foreclosing party, plaintiff or defendant, depends if you're in a judicial state or a non-judicial state, so I say foreclosing party and borrower, and that works fine. Once a non-judicial foreclosure has happened, the rest of it's all the same. The two aren't different after that. Anyway, if your judge has the responsibility of burden of proof, and he's placing it on you, the borrower, yet the borrower is specifically excluded from that burden. The burden of proof, the burden is on the attacking foreclosing party, It would be the plaintiff and all other contract law, and real estate and home loans are contract law. The attacking party, the foreclosing party, if you're the plaintiff in a non-judicial state, they have to answer what you sued them for, and you sued them for what you're going to sue them for, if you listen to me, is deprivation of civil rights, deprivation of constitutional civil rights, and lack of Article 3 standing. It's the judge's responsibility to read the first thing that you both wrote at the beginning, and that's where you guys, I'm losing you. You keep wanting to go back and argue about the judgment that the judge made, and then you've got 6 years of stuff you want to tell me, and that takes up a tremendous amount of time. That's why I wanted to do, I'm doing my own cases, and I don't make any money off the website, none. I'd like to make enough money to carry on and help, and I've been helping for a long time. I've spent $300,000 of my own money, and I didn't have a whole lot more than that, and so I'm kind of struggling. But if I can talk to 10, 50, or 100 people at a time and let them ask me questions, and we learned this in the coronavirus, this virtual meeting, it can work fine. And so I learned about virtual meetings, and I'm going to do Zoom classes. I always wanted to teach this. I have been talking to a junior college. I was going to teach there and do classes for the community to come to the junior college. I'm in Kansas City. Anyway, so when we're talking about civil rights, it sounds way too complicated. One moment. What I was beginning to say is that where I'm losing you is when I start talking about the Constitution, you don't see how that fits. And that's because we're all brought up to believe in your banker. And why would they cheat? Surely there's regulation. Well, if you read what I write, there is no regulation, none. Hadn't been any regulation since 1999, and there had been from 1933 to 1999. That's not what we're going to talk about today. We'll get to that soon. But you're looking for an answer to try to pound the judge again, the same guy that has over and over not followed the law. You're trying to convince him that you're right. And you think if you keep giving him better stuff, better citations, better regulations, better reasoning, that he's going to go, oh, that's what you were talking about. My God, I've been throwing people out of their houses for 12 years. That's not going to happen. He knows what he's doing. Now, if he may think he's right. There's only 3 things I can think of that would cause us to have universally in America, United States, almost all the judges doing this the wrong way all the time. The judge is to review the first things written, what you said and what they said. The burden on them is to claim that they've suffered an injury. It's called an injury in fact. So they have to claim they have an injury. And this is, I've gone through hundreds of cases. I'd never have found it, ever. They never say they were injured. They say they have the right to foreclose, but they don't explain why. Okay, the way it really is stated by the Supreme Court, related to Article 3, is the judge is to review the writings of both parties at the beginning. The plaintiff, the foreclosing party, is to write down that they've suffered an injury. They are then to prove the injury with concrete and particularized evidence. Those are legal terms. You can look them up, Google it. You can Google anything I say. You can vet anything I say. Anyone can vet anything I say. And I get most, if I do percentages or if I do try to get portions of the group, I use Jackson County, Missouri, because that's where I live, but that's not the only reason. It's also the easiest place to look up the records, not of you. In most of your counties, when you go to try to look up documents that have been recorded against your property, you have to put in the grantor or the grantee. Well, that's not going to tell you anything at all. I mean, that's hopeless. You need to find out what has been recorded against the property, the legal description. It's the property that you purchased, the house. The house is incidental. You know, that's an improvement. And the house may be worth 100 times what the lot is, but what you buy is your legal description. So anyway, the foreclosing party has to say they were injured. They have to prove that they're injured with concrete particularized evidence, and they have to prove, and they have to trace, fairly trace, are the words, the injury to you. You gave them the injury. You've never seen that written. I've never seen it written, and none of these judges have ever seen it written. But that's been the law, I mean, forever. The Supreme Court has backed it up over and over. In fact, it won't be revisited again. It's called settled law. They won't look at it because there's no reason to look at it. It's right. Yet 20 to 30 million people have been foreclosed on, and each of those, in some way, you'll find the assignment of a deed of trust in non-judicial foreclosure states, or the assignment of a mortgage in judicial foreclosure states. And you can't assign that. All the mortgage is, and the deed of trust is another kind of mortgage, all a mortgage is the collateral agreement. The loan is the money you got, the debt. The note represents the money because the money's gone. You brought it to closing, or it was sent to closing by someone, and the seller got the money and he left. So there's no evidence of the money. The promissory note is the evidence of the money, and that is legal ownership. And I can also tell you that you all think that you have to have the promissory note. Article 9 of the Uniform Commercial Code tells us that possession of the promissory note is not evidence of ownership of the debt. You know, so this is all leading to the same place. Civil rights. If it's in the Constitution, it's a civil right. And we've seen the last 3 weeks people trying to exercise their rights. Their right to assemble, you know, their right to get a job, the right to be judged by the police only by the same rules and requirements of someone of a different race, that we're all equal. In fact, originally, they said we were all equal, but women didn't get the right to vote until 1921. Blacks got the right to vote in 1863, but they weren't ever really allowed to vote, especially in southern states. It was made hard, it was made very difficult. And so in 1964, through protests, through people gathering together to tell their story together, and that's where I'm headed, they assembled. And yeah, you read a few things where thugs burn things, and I can tell you that it's 50 years later from Watts, but what I saw was 99% of the people trying to keep everybody from making an ass of themselves, and to try to get the message across. And they've done a great job, and people are paying better attention. They paid better attention in the 60s than they did in the 50s. And what's the deal about women couldn't vote till 1921? What's the deal about that? So, civil rights apply to your right to be sued by only someone who has proven absolutely, concrete and particularized, means same thing as beyond reasonable doubt. You have a right to be sued only by someone who has the right to sue you. If your foreclosing party, and I say that because it's not a bank anymore, there's new names, it started with Green Tree, Nation Star, Aquin, but you're in foreclosed on a servicing list. Your original loan, someone got a servicing list, but the money didn't even come from who you think it was. It's not the person on the promissory note. We're not going to try to prove that. We don't have to. If the judge moves his case forward without having written his review of what everybody said, and I didn't finish that. I told you what the foreclosing party had to do and what the judge has to do. The burden of proof, the burden on the borrower is only to say, I was not in default with this foreclosing party herein. I wasn't in default. And you weren't. It doesn't matter if you haven't paid for 2 years, 5 years. Who were you supposed to pay? We've all heard that judges have said, and I've had 2 of judges in my cases say that a borrower's not going to get a free house from me. Well, I can tell you right now, is I put over $200,000 into my house at closing. And my foreclosing party was GMAC Mortgage LLC. They didn't exist, and they certainly didn't put any money into my deal because, how do I know that? I owned the mortgage company. I made me the loan. I know what didn't happen. I know what did happen. And GMAC Mortgage is not related in any way. We didn't belong to MERS. We didn't know what MERS was. This was in 2004. We thought MERS was a new program because there was always some new software program for mortgages. So when I'm talking about the Constitution, I'm talking about you're out of play. You can think up more stuff. You can look at more stuff. Everyone I talk to spent more money. People say I've spent $16,000. I spent $25,000 on an attorney and got nothing. And so when they're talking to me, we don't have any money. What am I going to do about that? Same thing happened to me. I've been doing it since 2012. I've been doing this, helping people since before my foreclosure because I felt mine off for a while. Anyway, so we're going to talk about the problem is that if none of you believe that what I'm saying is correct, you're just going to run and you're going to fall into the trap that's been set for you intentionally, that you will exhaust your money, you'll exhaust your will, and you will exhaust your belief, and you'll quit. You're going to quit. I'm not going to quit, but I know more than you. What I want to do is come up with a solution, and there are solutions. We're going to have to go through or around the judge. If what's left to him to decide, you already know he's going to decide. How's this new filing that you're going to do, how's this new filing going to affect him in any way? He's already got it. You're done. You're cooked. If he's not even reading it, if he doesn't write down in his judgments exactly why the foreclosing party has Article 3 standing, then he's broken the law. It's an important law. Judges at the federal court level have absolute immunity. And at state level, they've got some immunity. A lot of immunity. But absolute immunity means that even if a judge takes a bribe, you can't sue him even if you lost because of the bribe. In other words, you're injured by the judge. But if you think about it carefully, if the judge took away your civil right to due process when he did that, that's completely different. That is a different setting. A judge cannot take a case, cannot take it, cannot move it forward, cannot even read the next motion if he does not have subject matter jurisdiction. If he did not review standing, if he's not written it down and given it to everybody and filed it, that here's why, and I don't even know of a case where I think somebody had standing, not since 1994, which is 1 year for Windows 95. Interesting side note, Jackson County, Missouri, 1994, 48 foreclosures for the year. After 1999, the repeal of Glass-Steagall Act, which is what we didn't talk about a while ago, but after the repeal of that, it was 9 short years before the meltdown happened. 67 years protected by an act that was put together by studying the Great Depression and saying, here's how we can keep it from happening again. And what the whole problem is that when Glass-Steagall was repealed in 1999 by Bill Clinton and a Democrat and a Republican Congress, they put nothing back in place. There's been no regulation. There's no regulators because there's regulations. How do they get away with this? we don't have anybody that's supposed to be watching them. And do judges come about this over a long period of time and they really do think they're right? Maybe. I didn't say 3 things I thought. A judge could be stupid. He could be just an ignorant ass. 1. He could be uninformed. His problem, his fault. If he's uninformed, he shouldn't take the case. If he takes a case, he needs to get informed. And if he doesn't know anything about the Constitution, then he became a judge after he was like a bankruptcy attorney, for 40 years, and then he gets appointed. I don't know. Okay, so it's stupid, uninformed, or crook. It cost me 4 years to believe that the courts wouldn't straighten this all out. I believed it. I believed it because I'm an American. I believed it because that's our system. And it's universal. There's very few judges, very few judges. And I'm going to give you some cases by judges that decided correctly and explained it. And that's how I learned it. So, if the question is, why should I watch these classes? Well, you should do it if you think the Constitution really is the law of the land. So we're going to go ahead and set up kind of an introductory class. I intend to do 5 classes. I'm going to have to just choose the date myself, which I will do, because I don't know what days. And I've got a form on my website, the website that you have to be watching this on. And if you'll fill out that form and tell me what days are best, what times are best, and there's other things I want you to answer on there, I'll try to match that up. But right now, I'm thinking about doing it this Sunday, the introduction. And at that time, it'll be an interactive class, and people can tell me what they think about what day, what time, whether they think that I was full of it, whether they don't think I'm full of it, But what I'd like to see is a whole bunch of people wanting to do it at the same time, all over, everywhere. Because that's the way the media is going to pick it up, and it's going to take the media to beat a judge. We don't want to beat the judge. That might take too long, and it's not. No one's doing it. I don't know of anyone doing it but me. The same way. No, I don't know anybody doing it but me. And I think that it's exposing the judge to the same amount of harm and injury that he's inflicting on you. Just like any trial, any court, you have to make the other side believe that something bad happens to them if they don't back down. So what does the judge need? Well, first of all, he needs for his career to stay in place. If he breaks the law, he can be disbarred. Also, when he breaks this particular law, you have the right to sue him. He is a citizen because he wasn't a judge, because he didn't have subject matter jurisdiction. He's a citizen, no better than you, no better than me. And if he caused injury to property or money, then you have a right to sue him. If you do, we're going to add RICO to it, and we don't intend to win with RICO. But RICO, once accused of RICO, a judge will never get over that. We want him to think we're going to ruin his career, and we're going to ruin his reputation. Does that sound mean? You tell me how mean they've been to you. Anyway, I'm looking forward to it. I've always wanted to do this. I hope this is going to be something that helps a whole bunch of people. And I hope you attend on Sunday. That'll be up today on the website. And there's also lots of other information, but especially get on that form and tell me what you want to hear me say. Tell me what you want to learn. Tell me why you think I can't teach it to you, or why I can, and when is best, and is it affordable? All right, Danny Hammond, Kansas City. Look forward to it. See you later. Bye.